In this video, we're going to look at the very beginning of the summing up of Judge James Goss from the trial of Lucy Letby. I've already begun to look at this critical component of the trial of Lucy Letby in these previous videos. Lucy Letby, what happened in Judge Goss summing up, and what were the very final comments of the Lucy Letby case. These focus on the very end of the summing up, but we're going to rewind in this video right back to the beginning of the summing up, which is an important part of the court case, as it is the last thing that the jury hears from the judge, in which he summarises what he sees as the overall evidence in the case. So I'm going to go through the entirety of this document as it's all available, and we're going to begin with the very start of the summing up in this video. So we're going to begin with this first chapter where there is a fairly comical mistake from the judge in the case. I'm going to read this section out in its entirety and provide analysis as relevant. So it begins with Judge James Goss saying, "Mr. Johnson, Mr. Myers, may I confirm I've received your respective documents? Subject to one or two queries, I don't know what you are specifically inviting should happen, Mr. Johnson." So I will refer to the judge as Judge James Goss, which is his name. I'm not going to call him Mr. Justice Goss because it's pretentious. This initial section involves a discussion between the judge and Nick Johnson and Ben Myers, where they have presumably reviewed his summing up documents and they've asked for revisions or not, as the case may be. So there is some discussion between the three of them regarding notes that Goss has made. So Nick Johnson says, "I was inviting my learned friend initially to make corrections, but I know his position is that there is nothing that requires correction. It's a document that points out issues we have raised." Then Goss says, "Can I say that there were points during the course of the speech that I was going to remind the jury of the actual evidence upon, so I am not going to pursue any suggestion of pointing to something and identifying it." So I'll invite viewers to see, or listeners, if you're listening, to see if you can spot the mistake in this passage. "I shall simply, in my narrative, which as you will learn shortly is going to be a recitation of the evidence, with very little, if any, well, there will be a little bit of comment here and there, but substantially no comment and no reference to it. There is just one matter upon which I do need your assistance. That's to do with Dr. Evans and the radiograph with air in the brain. There's one, isn't there? You say there are two. Mr. Myers says there's one." So even Nick Johnson here corrects him and says, "It was the heart, I think, not the brain." Now, I haven't researched whether or not it would be possible to inject air into the brain. I do know that the brain needs a significant oxygen supply. I think I'm right in saying the brain requires 20% of the body's oxygen, despite taking up only 2% of the overall volume or weight of the body. It does require an enormous oxygen supply, so it does receive oxygenated material, but I don't know if it's possible to inject air into the brain or not. Someone who knows more than me would have to say, but that was never the allegation, of course. It's pretty, for me, anyone can make a mistake, and I'm not here to be too harsh, but it is fairly incredible that the court case has been going on for months, 9 to 10 months. Admittedly, that makes it sound a lot longer than it was because they had a lot of time off. It's approximately 135, 136 days of actual court evidence and court proceedings. So really it's more like if you take the weekends out, it's more like 5 months really. So sometimes when they say it lasted for 10 months, I assume they were actually in court a lot more than they actually were. Nevertheless, it's been a long process. I think we can all agree on that. And to come out of that long process and think that there's air in the brain in an X-ray, when it's absolutely central contention of the court case, is incredible, I think. and it doesn't feel like it doesn't feel like a slip of the tongue, because there've never been any allegations related to the brain. No, the brain has never been discussed at any point. We can all make a mistake, and maybe he just did make a mistake, and maybe he really understood this aspect of the case quite well. But the fact that he has to be corrected on this and say sorry in the heart, there is reference to air, yes, all right, for me is not great. And then there's another fundamental disagreement in a bit, but I'll continue reading. So Ben Myers says, Professor Arthur's yes. There were two references which the prosecution identified, one during cross-examination relating to baby E, one during cross-examination relating to baby O. It's item 3 in the prosecution's list and also item 3 in ours. It's apparent when one goes back to the evidence that item 1 with baby E actually came out of questioning about that image from the Lee and Tanswell document. So notice they're discussing Lee and Tanswell immediately, although Dr. Evans still claims it wasn't important in the case. So it was in relation to the image, not to an actual radiograph. The image, yes. I just want to confirm with Mr. Johnson that you accept that. I must say I hadn't picked up that detail if that's right. And then Goss says, I've seen what you have said, Mr. Myers, and that's what I understood the situation to be. If that's right, then that's right. That's that. Then the other point in relation to this, as I understand it, is that Dr. Evans, when he referred to the great vessels, when he was talking about air in the great vessels, Dr. Arthur's my lord. So he made another mistake here of saying that Dr. Evans is saying something, but it's actually not Dr. Evans, it's Dr. I mean, should this guy be in charge of the case? I'll pose that question to you already. This is page 1. He makes 3 basic errors. First one, air in the brain when it's air in the heart. Second one, Professor Arthur's, not even Dr. Arthur's, as Ben Myers says is Professor. So it's not Dr. Evans, clearly. You're going to see the third one in a second. This one is more commonly known. This is only in the first page of discussion. So then he says, oh, sorry, yeah. Was referring to air in the great vessels. He was not specifically identifying the heart as such, but he made his comment in relation to one of the radiographs that there was air to be seen in the heart, and that was it. But then he didn't actually address that in any further detail. Then John says, well, one of the points my learned friend makes is that the prosecution haven't actually relied on air in the heart, and we never did because Mr. Judge Goss says exactly. I don't think you can have this air of as if you understand it really well at this point. It's a non-specific finding. The issue arose because we say it was being turned into a point. So sometimes they talk like lawyers in this summing up, and I don't really know exactly what they mean sometimes. But I haven't really thought too much about whether the comment of Johnson about it being a non-specific finding is accurate. I mean, it doesn't sound accurate to me. If there's air in the heart, surely that's a very specific finding. I don't really understand what he means by saying it's a non-specific finding. Someone can perhaps enlighten me. I don't really understand his comments. So then we're going to move on to discussion of Dr. Evans. So this is a more common known kind of oversight by Goss. So he goes, all right, there we are. Then there's one other thing, and I just didn't have the wherewithal over the weekend because I was quite busily engaged to confirm one thing. Sorry, there is another matter, Mr. Myers, whether Dr. Evans and Dr. Bohin are neonatologists. You expressly did not contradict their assertion that they were neonatologists. Their qualifications, which I shall recite, are that they have been neonatologists. So we're still on page 1, so he doesn't understand that Dr. Evans certainly is not a neonatologist and cannot call himself a neonatologist. Dr. Bohin, frankly, is little more than a card-carrying neonatologist. She's a neonatologist perhaps by name. Nowhere near it was she engaging in practice to the level required to really be considered a practicing neonatologist, but she can call herself a neonatologist at least. Dr. Evans definitely cannot. So then we have Ben Myers saying, we accept Dr. Bohin by training at least and experience on the face of it as a neonatologist. Our cross-examination of Dr. Evans, and in fact I'd be grateful if this is a matter to deal with, to give your lordship the correct references, but it was plainly directed towards the fact that he didn't have. We questioned that he had the relevant experience and that he was a paediatrician by training. His evidence was that he had spent a lot of time working in neonatal units, but we were drawing that distinction most definitely. It would help probably if I could find your lordship that reference. In the course of submissions to the jury, we said he was not a neonatologist. We didn't actually say that about Dr. Bohin, and the passage identified by the prosecution was a reference to them not being in the same league as Dr. Barbaro. And we dealt with that in this response under item 1. And Judge Goss says, right. It's important because the prosecution's document, Ben Myers continues, has taken a passage from my submissions, and it said that, I'd like to just explain this to my lord 1 moment, please. You see how long-winded everything is? I mean, this is what it's like. They can't ever use 1 word when you could use 10 words. I mean, I wonder if they're like this when they're not in court. You know, if they're just having a conversation, if you're like in a pub with them having lunch, you know, when they order, do they take 5 minutes to like order the fish and chips? I don't know, but it really does go on quite a bit, this summing up. There's nothing I can do about that. Yes, it's right under item 1 where they say there are several things that were said, and they put the quote from my speech. Dr. Evans is not a neonatologist, no matter how he boasts of his credentials, nor is any other prosecution in this case. We understand that by putting it in square brackets, the prosecution was shortening what was said, but what was said, he is not a neonatologist, and we put this in page 6 of our response. We didn't say not a neonatologist, we said Derek Evans is not in that league, no matter how he boasts of his credentials, nor is any prosecution witness in this case. Then Justice Goss says, I don't want to get involved in the semantics. No, I know. All I wanted to do is tell the jury what the actual situation is, not what they may or may not be described as. My proposed summary, and I would be grateful if counsel could listen to this, would say that he's a consultant paediatrician who is in full-time NHS clinical consultant paediatric practice in Swansea from, and then I need help on when it was. I've noted 1980. There's another reference to 1986 somewhere. I'm just wondering if someone could look up the report to confirm exactly what the correct date is, but we can pass on that. To 2009, he was responsible for setting up, supervising and leading a neonatal intensive care service in Swansea from his appointment, developing intensive care services from scratch. His experience was very much hands-on. His operational and managerial roles, including serves as Clinical Director of Paediatrics and Neonatology in Swansea between 92 and 97 and 2004 to 2008. Neonatology is the care of babies up to around 4 weeks of age. I hope that accurately represents what his experience and qualifications are. Yes, it's 14th of October, which is day 8, and it's page 7 of the transcript. I can read what he said. If you would please, Judge Goss says. So Johnson continues. I qualified from the Welsh National School of Medicine in 1971. I carried out my first paediatric post 18 months later. So my paediatric junior training took place in Swansea initially, then in Cardiff and in Liverpool. Each phase of my training involves specific training working in a neonatal unit. Then he says, I was appointed consultant paediatrician in Swansea in 1980. The most significant part of my brief, I think, was the development of newborn services for babies, particularly developing intensive care services for babies, which we did from scratch, really. Then I asked, how would you define your role in the development of those neonatal intensive care services in South Wales? He said Swansea was one of the bigger units in South Wales, so we covered the area extending throughout the whole of South West Wales over time. Initially, it was very much a matter of getting on with it, trying to get good equipment, getting the nurses, and... So this is Johnson just trying to inflate his credentials, and Goss says, quite reasonably, I don't need that. So then Johnson goes, and then, so therefore we developed all those services during the 80s and 90s in Swansea, and Goss says, I think I've summarised it accurately and fairly. It was just the date of 1980 I wanted. And Johnson says, yes. Then Goss says, which I had written down, and then somewhere else I saw 1986, but there we are. So your complaint, Mr. Myers, or your criticism of him is that he essentially trained as a paediatrician, specialised in neonatology, but doesn't have, that is the extent of his experience as I've summarised it. Ben Myers says, it is. My lord, just so it's plain the way we dealt with it, and I found the reference, when we cross-examined Dr. Evans on the 14th of October last year, and this is for your lordship's reference, at page 70, line 12 on day 8, 14th of October through to page 71, line 18, we established with him that he's not a consultant neonatologist. It was put to him, you're not a consultant neonatologist, are you? He said, answer, I'm a consultant paediatrician, that's correct. You are a consultant paediatrician, you have significant experience in neonatology of over 30 years, yes. We went through that with him. It was put to him, the bulk of your experience in neonatology is via the unit you set up in Swansea, correct. And that was during the 1980s into the 1990s. And he added, and the 2000s. So it was over that period from the 90s to the 2000s. So in that sense, we wanted to say you weren't someone who was working exclusively in neonatology. That is correct. So that was the type of issue. I understand. I'll refer to that. Thank you very much. I don't think there are any other matters that I need to continue with, unless there's anything you want to say, Mr. Myers. We don't enlarge upon the written material your lordship has had. We understand the process your lordship is engaged with and our concerns were there. I won't reiterate all of that now. Your lordship has that and we can proceed as your lordship sees fit. I'm not going to engage in a process of correcting, Goss responds. All I'm going to do is tell the jury what the evidence is and say, this provides the context of the submissions that you have heard. In other words, I'm contextualising the submissions. Maya says, yes, we understand that. With that in mind, your lordship knows we don't accept the description of correcting, although I won't dissent to the arguments which were given to your lordship, but we have put the corresponding evidence and issues alongside those, and we may do that yet if we have the opportunity with the other matters that were raised, though we take it that your lordship does not take these as a guide to what is said in summing up. Then Goss says, what I will do is simply, when we have breaks, of which there will be quite a few over the course of the next few days, I will invite counsel if they wish to correct anything that I have said which is erroneous. I'd be very grateful for you to correct me. But what I will not engage in is seeking to advance arguments. You wouldn't expect that in any event, but simply any corrections, and I hope there will not be many, but there is a huge amount of material, and of course this is a summing up. This is not a recitation of all the evidence, and I'm not going to descend to arguments and counter-arguments. I will simply set out the general positions of the prosecution and the defence, and then remind the jury of the evidence, giving them references, but not, and I'll tell you this now so that no one is in any way surprised, I'm not going to invite them specifically to look at documents, as I'm not going through my summing up because they have the documents. I shall make references and invite them to note references if they so wish, but I am not going to start, because if I started, where would I stop? And we would be here for weeks. Ben Meyer simply said yes. So that is, as you will hear in a moment when we start, the format of the summing up. As I say, I would please welcome corrections. My lord, we understand Ben Meyer's response. And Goss continues, which can either be done in the presence or the absence of the jury. It might be better if they're done in the absence of the jury, I think. We agree, Ben Meyer says. All right, would anyone object to the usher distributing? Is it easier for you to distribute when the jury are in place? Then there's a pause, in the presence of the jury. So presumably this is not happening in front of the jury. So you can see from that short section what a grueling experience the trial must have been. It's like running an ultramarathon. I'm not going to do any commentary on that. You can pretty much understand what happened. The prosecution are trying to inflate the qualifications and credentials of Dr. Evans, and the defence is trying to delicately point out to Judge Goss that he's wrong to state that Dr. Evans is a neonatologist, as he was going to do. Now, in the interests of being as exhaustive as possible, I'm going to go through all of this summing up. That's just 7 pages. We're on page 7. I've done some at the end, and there are some notes at the end of this document. Clearly, I'm not going to do this in 1 video, 2 videos, or 3 videos. It will be a large number over a long period of time. But it is going to be a long process because it goes on for so long. So the next section is legal directions. Now, I'm going to be as completist as I can with this document, but in the interest of relative brevity, I'm not going to look at this in full because it's really not very interesting, and it's going over stuff that we already know, that we've already established. For example, there's a discussion here of the number of babies, blah, 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 and so on. And there's discussions about whether there have been more deaths in previous years, less deaths, etc., etc. It's stuff that we've been over many times. I just want to mention the 3rd paragraph. So this is right at the start of legal directions. This is almost the first thing that the jury are hearing in the summing up. A number of the babies were subjected to what the prosecution alleged were repeated attempts to kill them. After a year, it became clear that, of all the nursing staff and doctors, the defendant and her alone was at work on the unit at relevant times and was sometimes present when unexpected collapses occurred. So note, even the judge doesn't say that Lucy was always present in the summing up. But the argument that's being made here is central to the entire prosecution case, and indeed it's front and centre in the summing up of the judge. So this idea that the shift chart is not important in the case, it's critical. It's absolutely critical. But another thing to understand, and anyone that believes Lucy Letby to be guilty at this point, I want you to understand this. I've made this point several times previously, but I want you to listen to this very carefully. The way that the prosecution case was constructed, it is absolutely hypothetical. We know the medical information is really poor. But leaving that issue aside, Lucy Letby could easily have not been the defendant in this case. If someone else had simply been around, present when unexpected collapses occurred, as is stated here, it's not even stated she's always present, it's stated she was sometimes present. So if someone else was simply present more often than Lucy Letby, or if right at the start, if Dr. Breary had happened to notice someone else, a different nurse, they would have been the defendant in this court case. Lucy Letby would have been quite possibly part of the court case. She might have been called in as a witness, or she might not have been called in as a witness and she might still be working at the hospital. And one of the other nurses would be a defendant and probably now in prison. That's what you have to understand. There was no meaningful concrete evidence. Well, there was no concrete evidence at all. There was no meaningful circumstantial evidence. It's all based on a hypothesis of coincidence. And if it wasn't Lucy, it would now be someone else. Lucy Letby would be a minor figure in this court case, and someone else would be in prison for her supposed crimes, just because they were around more often than she was. Let's say she'd been ill. Let's say at the time these collapses happened, all of a sudden, let's say Lucy got a serious illness. It wasn't the times of COVID, but let's say she got something like COVID, and she had a virus for 6 months. Sometimes you get glandular fever, it's really bad. So she was off work, it dragged on for a long time. Then she had tiredness, and she was out the picture. So they drafted in agency staff to replace Lucy and tried to get some of the other nurses to do more shifts. Some of the other nurses did more shifts. And right at the start, instead of seeing Lucy, Dr. Breary saw one of the other nurses. I won't name one of them, so I think that's an unfair thing to do. But we all know the names of the other nurses, or that they're widely available. Then he would be thinking, well, that nurse seems to be around a lot of the time, and then he would have become obsessed with her. Lucy would have come back to work on the unit. She wouldn't have been under suspicion. And now that nurse would be infamous. She would be the equivalent of what Lucy Letby is now. She would be in prison. She'd be in Bronzewell or wherever it is. And we'd be campaigning for her release. And Lucy Letby would be no more than a fringe figure in this whole debacle. So I want you to understand that's a inevitable outcome of the way this case has been constructed. We know about how it was constructed in court. We know about what the police did now, and we'll be discussing more of that in the future. We know about Dr. Evans. We know about how weak the medical evidence is. But the most important thing is, at the heart of this case is a statistical coincidence. That's all it is. We know that's what Dr. Breary saw. We know he didn't have any other evidence. We know that it was passed to the police with no other evidence. And if it wasn't Lucy that was currently in prison, it would simply be another nurse from the unit. That should be a wake-up to anyone that believes that Lucy is guilty. I don't suppose it will be for 1 second, but it should be. So I've read through all of the legal directions for this case, and in this summing up document. I'm not going to go through them all as I mentioned, but I just want to read this passage as well. The reason I'm not going through it all is because it's stuff that we all know. It's stuff that is well established. I don't want to go over the points that are wrong in it yet again. There's going to be an enormous amount of information in this summing up that we're going to go over, and we're going to go over it in relation to the infants, which is more significant. These are just general comments about staffing, nursing, and the hospital. But I do want to read the passage that's highlighted here. There were 7 consultants at that time. Dr. Gibbs explained that every specialty in the NHS wanted and wants more staff. An increase had been planned for many years and was necessary because of the need to comply with the European Working Hours Directive, which was applicable at that time. Also, they'd sacked loads of the staff. Probably should mention that. That didn't seem to be mentioned in court, but we've heard Michelle talk about that. There's more detail about that in my book. But they just sacked loads of people for cost-cutting reasons. It's actually the significant thing there about talking about complying with the European Working Hours Directive. That's breezed over very, very quickly. But what that, of course, implies is that they were requiring people to work long hours. So this feeds into the thing that I've just mentioned. They didn't have enough staff on the unit, so they're looking for people to do extra shifts. Lucy was the person who did extra shifts. So she was working too many hours. She shouldn't have been working as many hours as she did. The only reason she did that was because she was saving up for a house, and she got a deposit and she got a house, and she thought her life was on the right track and about to really begin. And then they would have brought in more staff to comply with, basic requirements under the law for employment. And if it was just someone else, let's say Lucy had been more comfortable financially, And she said, no, I don't want to do those shifts. I'm fine, which is what I always did when anyone offered overtime when in the jobs that I did. I work incredibly hard now, but when I had a job, I couldn't get out there quick enough. I mean, I never once took overtime anywhere that I worked, but other people would. So I would have been okay in this hospital. I've been like, I've had enough, I'm going home. Someone I would have never been accused in these circumstances. And if Lucy had turned down the shifts, she probably wouldn't have been accused. Someone else would have been offered the shifts, and that person would have been identified, quite possibly. But this is a significant aspect of the case again. But then it moves on to say something else that I will explain and analyse as well briefly. This was a nationwide problem in paediatrics. I'm not sure that's true. I mean, I very much doubt that's true, given what happened at this hospital. And I think we all accept that there are problems in the NHS. There probably are problems in paediatrics. There probably are widespread problems in hospitals. But the problems of the Council of Chester were very specific to their circumstances. Their circumstances were that they got rid of loads of experienced staff by their own choice so that they could cut costs. That's not, you can't just say glibly that's a nationwide problem. That's flippant, and I think that's untenable as a statement. But let's continue. Dr. Gibbs said it would have been better if more consultants were available, but he refuted the suggestion that there was any compromise of the appropriate level of care given at that time. There was a consultant of the week, this is the bit that I particularly want to read, there was a consultant of the week who covered both the paediatric ward and the neonatal unit. So already you'd say that is not ideal. I'm sure, I mean, we've mentioned this previously, but any number of doctors will tell you that's not ideal. That style of cover was common for District General Hospital and one that they had followed for many years prior to 2015. So that might have, this is, I mean, a kind of a key detail. There's a few things we need to point out here. Having someone covering the paediatric ward and neonatal unit is not ideal. Everyone knows that. Certainly people with qualifications know that. That's the first thing. Secondly, the style of cover may or may not have been common. That's debatable. But it was probably fine. They only were a level 2 unit for a very short period of time. It's literally 5 years. And they had problems in 40% of those years. So they didn't have a fantastic run as a level 2 hospital, and then they've been downgraded, never to be upgraded ever again. So the way they talk about it throughout this case, it says, oh yeah, we never ever had any problems. But actually they had problems in 2 of the 5 years that they were a level 2 unit. They had problems nearly half the time they were a level 2 unit. And it's a small sample size, but the reason it's a small sample size is they weren't allowed to be a level 2 unit for very long because it was going so badly for them. So, yes, they were following it for many years prior to 2015, and they've changed their policy now, which I'm going to get onto in a minute. But it's irrelevant because they were a completely different type of unit prior to 2015 for most years, and indeed after 2016 they're a different type of unit. It's not as if they spent years and years and years doing this type of work and then, they just had a couple of errant periods. But even if they had, that doesn't mean there's any malfeasance. That can happen, as we've discussed many times. That can happen in any system. But the fact is they were only a level 2 unit for 5 years, and as soon as they had a difficult acuity with difficult cases with twins and triplets, it crumbled immediately. So they actually had subpar results in 2 of the 5 years, so as I say 40% of the years. So this is all crucial context that's not being given to the jury. And then the last thing I just want to mention is the ward rounds are never mentioned in the summing up. They're never mentioned in the court case. So this incredible oversight that if you look at the Care Quality Commission report, as I've mentioned, other areas of the hospital, other departments were doing things correctly. Why the neonatal unit, one of the units that most requires ward rounds, arguably the unit in the hospital out of all the units that most requires ward rounds, wasn't doing it correctly or even close to being correct. It's very difficult to understand. I don't think there is an acceptable answer to that question. It's just simply incomprehensible. So the next section is nurses. I'm not going to read this section because it's not particularly interesting and not particularly relevant, and there's an enormous amount to look at and analyse, as you can see. I am going to read the next section, which is on staffing levels. A number of neonatal practitioners, Nurse A, Caroline Bennion, Nurse B and Caroline Oakley and Catherine Percival Ward, now Percival Calderbank, and Belinda Williamson, then Simcock. It's nice and easy to follow, I'm sure you'll find, were asked about staffing. Nurse A said there were periods when they were short-staffed and they didn't always reach the BAPM guidelines, to which I shall refer, as they have been during the trial. So I'm going to discuss the BAPM guidelines shortly. Ideally, there should be 2 Band 6 nurses on any shift. Sometimes there were potentially more babies in the unit than there were meant to be. When a shift was a bit short of staff, a nurse might be asked to staff a shift or do an extra shift, and there would be flexibility with the rota. Nurse A also said they always had a lot of senior staff who supported the junior staff, but 2015 to 2016 was a busy period with more babies requiring a higher level of care, higher acuity, and there were times when the BAPM gold standard could not be achieved. Again, I'll discuss this shortly. Melanie Taylor remembered there were a lot of busy shifts around that time. Nurse B also said the unit was very busy in 2015 to 2016. Admissions seemed to increase and they had far more intensive care babies. It wasn't always possible to follow BAPM guidelines on staff ratios, but staff were giving up breaks to provide care. Caroline Oakley didn't remember the unit being unduly short-staffed. There were always a lot of babies and it was always quite busy. Catherine Percival Ward, now Percival Calderbank, said there were a lot of babies that became sick at that time and they were particularly busy. Belinda Williamson said at times it was difficult to get hold of a doctor when needed, particularly at night if the paediatric ward was busy, but in relation to nurses she said it was rare for there not to be 2 Band 6 nurses working on any shift, as the BAPM guidelines provided. In his evidence, Dr. Stephen Breary accepted that staffing levels were lower than BAPM standards during this period when the college, this is the Royal College of Paediatrics and Child Health, reviewed their care in September 2016. It was also noted in that report that this was similar to other units, and at the time when these events happened, their staffing levels were better than all the other local neonatal units in Cheshire and Merseyside at that time. Those units didn't have the same mortality problems as the Countess of Chester. So with regard to these BAPM, British Association of Perinatal Medicine assertions, what is actually the case is that the unit never met the standards of the BAPM set throughout the entire period associated with the court case. And Dr. Breary knows this. Dr. Breary has to concede this because in the Thirlwell documents, he makes certain provisions and certain suggestions in order to attempt to lift the unit up to those levels. And when the Care Quality Commission gave them a very soft report, but they still said here, nurse staffing levels on the neonatal unit did not meet standards recommended by the British Association of Perinatal Medicine. That's only one way in which they didn't meet those standards. 2 key ways really are firstly the staffing levels, and secondly, the unit was too cramped with too many infants. So given that they have bacteria and conditions such as sepsis on the unit, that's extremely important. Other viruses are circulating as well. So when you have the cots too close together, naturally that can result in things circulating more readily. But they didn't meet the BAPM standards in numerous ways, and there's just a few documents on the screen indicating this here. With regards to the staffing levels, it would be impossible for me to go through all of the documents from the Thirlwell inquiry that indicate the staffing levels were suboptimal and inadequate, but I'll just mention that in an article that reviewed and summarised the Thirlwell inquiry, The Guardian devoted an entire section to the understaffing. With regard to the individual comments, it's noted here that 2015 to 2016 was a busy period with more babies requiring a higher level of care, higher acuity, and there were times when the BAPM gold standard could not be achieved. That's all true. The first thing I'd say is I think the initial comments downplay the situation somewhat. The situation is more serious than is indicated there. And secondly, it's not the BAPM gold standard couldn't be achieved. Some of the time, it wasn't achieved at all for any of that period. That's just a fact. With regard to this, Caroline Oakley didn't remember the unit being unduly short-staffed. There were always a lot of babies and it was always quite busy. So that's obviously anecdotal evidence. We actually know for a fact that they were short-staffed, and we know for a fact that there was more babies than usual, and we know for a fact there was high acuity. That's not to knock Caroline Oakley, but obviously anecdotal evidence is not typically required as being typically viewed as being gold standard, except in court, of course. But it's just someone's recollections of what was happening at the time based on their personal experience. Really, it's irrelevant. As you see here, Catherine Percival Ward says the complete opposite. She says there were lots of babies that became sick at that time and they were particularly busy, so she completely contradicts Caroline. She is in fact correct. We know for a fact she's correct. But the point is that if you ask someone's opinion, it's very much coloured by their personal experiences and perspective. And then, of course, they're remembering events 6-7 years previous at this point. This is significant from Belinda Williamson, where she says, at times it's difficult to get hold of a doctor, particularly at night if the paediatric ward was busy. So this is when the collapses have occurred. Many of the collapses, or they had collapses during the day as well. But we've mentioned in numerous videos this importance of monitoring the infants. And firstly, they don't have the ward rounds. And secondly, it's hard to get hold of a doctor when required, which means that critical things can go unnoticed, critical things are not responded to. And again, as nurses have told me, and doctors, these infants, when they're premature, when they're low birth weight, when they're neonates, they can collapse very quickly. Things can deteriorate rapidly, and the situation is never rectified, and it can be literally a matter of life and death. So not having a swift response, the most glaring example of this is in child D's case, where there's the mistake with the antibiotics not being delivered in a timely fashion, to say the least. But there are many other examples, and Belinda Williams is just documenting that here. And it all really comes down to what you can see on the screen now. But if you're not looking at the screen, what is on the screen is a big pile of money. And that's what all of these things, all the decisions at the Council of Chester, all the problems with the Council of Chester, all the problems with the NHS, pretty much everything that happens in the world is related to money. When you see big system decisions being made, it's always due to cost, expense, money, greed, almost always. And ultimately, the whole issue at the Council of Chester comes down to money. They firstly shouldn't have tried to be upgraded to a level 2 unit because they weren't good enough, and they definitely shouldn't have done it having sacked loads of people because they were trying to save money so they could cut costs for various reasons. The political aspects of the NHS are well known. We'll discuss them yet again in future videos, no doubt. A good deal of questioning by Mr. Myers and his submissions to you. So the judges addressing the jury there, of course, was directed towards staffing levels and the level of care provided by both medical staff and neonatal practitioners, and in some cases, the level of experience in dealing with some of the more vulnerable neonates. So I'll just reiterate, in this most extraordinary of cases, that he's referring here to their level of experience. And prior to that, in the previous line, he uses the term neonatal practitioners. So, of course, this is a neonatal unit without a neonatologist, which I continue to find extraordinary. Should you upgrade a unit to level 2 when you don't have a neonatologist? Even in ideal circumstances, I would say no. But given that we know there were problems with staffing, we know there were problems with people being stretched too thinly at every level of staffing, so nurses, registrars and doctors, consultants on the unit. So it's clear that their level of experience was suboptimal and subpar, even, I would say. But they don't have the basic skill set to begin with. I don't think they should have been upgraded to a level 2 unit in the first place, but as soon as the acuity became difficult, they started dealing with these complex cases. They had a lot of ill babies, twins, triplets, etc. Michelle in my book has used this expression, it was a disaster waiting to happen, which is exactly what it was. There is evidence of occasions when, contrary to the standard, a nurse on a shift was the designated nurse for more than one intensive care baby. There is also evidence of occasions when nursing staff complained about particular shifts and when care was suboptimal, in other words, not as good as it should have been. So I would say that strongly downplays it, but I'll continue reading. The potential relevance of this evidence in the trial is whether any specific or identified failing of or by any of the clinical or nursing practitioners, whether by way of inexperience or competence or numbers on duty at any time or by error, was or may have been relevant to the deterioration of any baby or to an event that you are considering. So, actually, I'll just read the next paragraph and I'll reflect on that. In particular, whether a failure of care or mistake may have been causative of the sudden deterioration in the condition of any of the babies in this case, or adversely affected their chances of recovery, and if so, which. For example, there was an admitted failure to give baby D antibiotics after birth and a delay in giving surfactant, about which I shall remind you. So the thing is, what this information about the staffing levels, about BAPM standards, about the very evident problems on the unit, which have been minimised in this court case, and of course as well the jury hasn't heard about a lot of very important problems. But what it is contextual information. No one is saying, I mean, he uses the word causality, causative, whether a failure of care or mistake may have been causative. No one is saying it's causative. It can't. It can be a factor that contributes to an overall picture. It cannot literally cause the collapse of an infant. It's never causative, because you could just have a neonatal unit. You could have no staff. Put all the babies into the machine, connect them to the machinery that they will be connected to, respiratory support and all such like. And then just say, right, we're going to have no staff on the unit, no one's going to monitor everything. All of the babies will die. But the cause of that isn't no one being on the unit. That's a massive blunder, obviously. And the outcome is inevitable, but the cause will be various medical conditions. The problem in this court case is that the jury only heard about the problems on the unit. And even then, they didn't hear about all of them. They didn't hear about all the medical errors. But they didn't hear about the conditions. The failures in care and the mistakes and the understaffing, they're all factors that contributed to the overall picture. They didn't cause the deaths of the infants. They were, I mean, the one, he does mention one here, failing to give antibiotics, that you could argue very strongly was the cause. But understaffing and not having enough cot space, that can be a very major contributing factor, of course, in a unit that has infection. But they're not causal factors. They're contributing factors to an overall clinical picture. Like if you have an inexperienced nurse, that doesn't cause the death of an infant. What causes the death of an infant is like if you put me in there as a nurse on a unit, there are going to be major problems. But I haven't caused the problems. I've just failed to recognise the problems that exist. And that's what is lacking in this court case, is that it's not failure of care or mistakes that are causative. They compound the causes of the problems that the jury in the court never get to hear about in this court case. So what happens in this court case is that the jury is given a compelling narrative from confident experts that Lucy Letby went around engaging in malfeasance and causing harm deliberately, and they're given a story in relation to that, and they're never given a counter-narrative. This is something that, again, I've covered in my book in some depth and spoken to some experts on juries and on this matter generally. But they're not given a proper explanation. It's just, right, Lucy Letby did this, Lucy Letby did that, then Lucy Letby, just relentlessly being driven home. And then Ben Myers doesn't give them any experts, doesn't give them a counter-narrative and just says, oh, but look, they didn't have enough nurses on the unit. Now, obviously, that's not going to be enough to counteract the very strong story that they're given regarding Lucy Letby having engaged in malfeasance. So the jury are given a completely false impression. They lean towards the more convincing story. And you see that here in the summing up, where the judge is saying, well, you need to look at whether the problems they had on the unit caused these issues. Now, in and of itself, the fact that they had problems with the way it's presented here in particular, where it's even downplayed, the fact that they had problems with staffing, and the fact they might have not had enough nurses and not quite met the British Association of Perinatal Medicine standards, and you hear about this just avalanche of collapses and deaths on the unit, of course that doesn't seem satisfactory to explain it. Of course it doesn't. I still think that the jury can sit there and think, well, there's reasonable doubt. But we know people don't understand things. People don't, even though it's strongly emphasised. I believe Anna has spoken about this on this channel, but other people will talk about it in the future as well. You can taste the jury until you're blue in the face. She has to be guilty beyond reasonable doubt. You have to basically be certain. And they'll still disregard it. They still won't understand that the defendant doesn't have to prove her innocence. You have to prove her guilty beyond reasonable doubt. They will still fail to understand this. They will still think there's no smoke without fire. What about all these collapses? Look at the experts we've heard in this case, etc., etc., which is why you need a strong counter-narrative. And if that doesn't exist, and if you just find yourself, as we're seeing in this summing up, we've got the very strong narrative that's been communicated to people through the court case, and we've seen it communicated through the media as well. And we know what an effect that had on Liz Hull, Judith Moritz, even Josh Halliday from The Guardian said that he thought Lucy was probably guilty at the end of the court case, and now he thinks it's probably a miscarriage of justice. I mean, I'm paraphrasing what he said slightly. But it had a big effect on people that observed it, people that read about it, and it must have had a big effect on the jury. Obviously, we can't speak to them directly. And this summing up absolutely exemplifies that. Because we see such a weak case. What the jury needed to hear about was everything that's now in these reports and everything that's been uncovered since then, which they never did hear about because the expert in the case, who ran the case for the prosecution, discounted all of these things, didn't even search for them, as we know now, and there were no medical experts for the defence. So it was about as an open a goal for the prosecution and for Dr. Evans as they could possibly have asked for in a case of this magnitude. It couldn't have been any easier for them, and still, when he was cross-examined, he got an absolute hammering. So I'll just read the last paragraph of this section. In the great majority of cases of the babies in this case, the defendant herself accepted that staffing levels or negligence in their care or treatment of them played no or no causative part in their collapse and or death. So on top of everything I've just said, the judge has now told the jury the one thing that we're defending Lucy Letby with, she's just accepted it played no causative part. So he's almost crossing that out immediately. So he's virtually giving the jury now no choice. The only choice the jury has is to be able to look at it and think, this is all theoretical, this is all hypothetical, no one's seen her do anything, she can't be said definitively that she's at these incidents, although they might not have understood that because the chart was presented which suggests that she was there all the time, even though Judge Goss has just said that she wasn't there all the time. We know she wasn't there all the time, but this is their only way now to be able to see this as miscarriage of justice, is just to have the intuition that I had when I heard about this on the radio, of just thinking, as soon as you haven't seen any acts, and as soon as you're looking at these quite arcane methods of murder, and there's many of them, and it's quite extraordinary, and it's in a hospital, and infants can die, and it's premature infants, and they're inherently vulnerable. I could, even though I know so much more about this case now, obviously, I could intuitively sense this within half an hour of listening on the radio. I had the advantage of not having sat in the court case for 9 to 10 months. I believe I would still be able to see that this case wasn't proven beyond reasonable doubt. I can't say that with confidence or total confidence because I haven't been through the court case. It's harder for the jury, and I acknowledge that. But you need someone who has a lot of intuition and a lot of critical thinking ability, which a lot of people don't have. Luckily, there are a lot of people out there who do have this, and a lot of them are now writing things on social media for Lucy that have been there since day one, and I must emphasise many of them were there before me because they heard about this case before me. They were following the court case. You've heard people on this channel say I was astounded when she was found guilty. I wasn't astounded because I hadn't followed the case. Pretty soon, once I did find out about the case, I was astounded. But in the initial 30 minutes, when I believed Lucy Letby to be guilty, I listened to a summation. And then at some point, my brain started thinking this could easily be a miscarriage of justice. And thankfully, that intuition was correct. But there's been a lot of other intuitive people who came before me who knew that this was a highly dubious conviction. Unfortunately, I know from being around the general public that's not a normal level of intuition. And if they don't understand medical matters, and frankly, the jury is not necessarily the best among us. I mean, someone made a point to me recently that it's debatable what members of the public would actually be able to participate in a jury trial that lasts for 10 months. Ideally, you'd want very intelligent people, very strong critical thinkers, and the kind of people that would be able to provide those skills typically may be able to get out of it because they may be able to say, look, I just simply can't take 10 months out of my life. It's just not possible. I don't know how the juries are selected, but someone suggested to me that the composition of the jury might not have been ideal. Now, I can't really comment on that because I don't know too much about the composition of the jury, but I can say that I know that it's not that difficult to pull the wool over the eyes of people generally, and I mean, I would say that with regard to people in my family. If the jury was entirely comprised of people of my family, Lucy would have had a better chance because I would have been on the jury and my brother would have been on the jury. But for some of the other family members, it wouldn't have been as great. And I don't say that to be rude or anything. It's just a fact. They're not educated and they don't think about things, and that's not the way they live their lives. And that's not the way most people live their lives. And critical thinking is not encouraged as well. So that would be necessary now because the judge has just he just said a little bit above this, he said, failure of care or mistake may have been causative, but the defendant has just said it's not causative. So basically the only defence Lucy's got in this case is gone. I suppose the last thing is trying to give Dr. Evans a hammering on the witness box and saying he's not a reliable witness, but he's also the only expert in the case. Yes, there's the other experts. They barely appear, as we're going to discuss shortly. But Lucy has no experts in her defence. None. So no matter how bad this expert is, we know he's pretty bad, but he's still the best expert in this case. So already we can see very early in this document the odds were stacked against Lucy, perhaps more than even people that have followed this case a lot perhaps realised. So the next section begins, I shall review all the cases for you. This is the last section I'm going to review in this video. I shall review all the cases for you, identifying in each of their cases the history of the baby, their condition, and the circumstances in which they variously required emergency resuscitative treatment, what was done and what was not, and the expert evidence in relation to the way that the clinicians and nursing staff treated the babies, and what the defendant said about any potential nursing or clinical mistakes. It will be for you to determine the relevance of these matters to the deteriorations, collapses and deaths. In his address, Mr. Myers said there was plenty of suboptimal care, that the doctors at the hospital have resisted criticism, and he repeatedly suggested that they were blaming the defendant for failings in what had happened and had gone out of their way to damage her and use it as an opportunity to cover bad treatment and poor outcomes. So I'll return to this paragraph in a second. He submitted that the evidence in relation to alleged types of harm inflicted was inconsistent with an intention to kill, suggesting why use different ways when an early alleged harmful act has been successful? Why change what worked? So I didn't know that was in the judge's summing up until I started to go through his document, but of course I've raised that point myself. It really doesn't make any sense at all. These and other propositions he advanced are not evidence in the case, rather they are inferences or conclusions he invites you to draw, which proceed from and are based on the defendant's position that she did nothing to harm any baby. As I have already directed you in my written directions 1, it is your determination of who is and who is not telling the truth and reliable, and the conclusions you draw from all the evidence that you make your decisions. It should really be on which you make your decisions. I shall endeavour fairly to refer to relevant evidence, some of which will involve you having to contextualise counsel's submissions, so you must concentrate on the detail and, if you wish, refer to documents, charts and notes. I am not going to put a single document up on the screen for you to look at during the course of this summing up, because you have them all on your iPads and can look at any you consider are or may be relevant when you are deliberating on your verdicts. So I've responded to one little comment there, but there's this other thing, this paragraph here. So let me just repeat this paragraph firstly. It will be for you to determine the relevance of these matters to the deteriorations, collapses and deaths. In his address, Mr. Myers said there was plenty of suboptimal care, that the doctors at the hospital have resisted criticism, and he repeatedly suggested that they were blaming the defendant for failings in what had happened and had gone out of their way to damage her and use it as an opportunity to cover bad treatment and poor outcomes. So I know a lot of people, and I don't necessarily disagree with this, believe that Dr. Breary and Dr. Jayram, we know for a fact that Dr. Breary and Dr. Jayram have a lot to answer for. They both appear in the court case, and Mr. Myers is suggesting they're covering their backs and they're blaming the defendant for failings. I'm not sure that was a conscious process initially, as I've expressed previously. But what Mr. Myers says here is that doctors at the hospital have resisted criticism. So essentially what you see in this court case, regardless of whether or not Breary and Jayram and even other consultants at the hospital are blaming Lucy for failings in what happened, they certainly went out of their way to damage her. Whether they did that consciously and maliciously is another matter. They could have done it because they felt they were doing the right thing, even though the way they went about it was wrong. I know other people believe otherwise, and there is evidence to support that. But that's not the point I want to make here. The point I want to make is that Mr. Myers says doctors at the hospital have resisted criticism. So a lot of this court case, as I'm going to demonstrate to you now, is just people who worked at the hospital either saying we didn't do anything wrong or we had no idea what was going on. So essentially they're being called into the court case and they're being asked, were you in the wrong? Did you make mistakes? Did you understand that there were problems on the unit? And of course they have to say no. They're not going to say, yes, I made loads of mistakes, or yes, I did realise it, but I didn't do anything. So, and then of course all of the criticisms from the panel of you missed this condition, there's this issue, there's this error on the unit. A lot of that they genuinely didn't know about because of their levels of competence. So essentially what has occurred in this court case for large portions of it is that the prosecution have got the people from the hospital in the witness box and said to them, did you do anything wrong? And they've said no. And the prosecution then said, did you have any idea what was going on? And they've said, no, we had no idea. We had no idea there were any problems. We had no idea there were any problems with the issues with these infants, etc., etc. And to some extent, you can say they did that consciously to defend themselves, as Mr. Myers is suggesting here. But also, it wasn't a competent unit, as we've established. So they can be saying, we had no idea what was going on. Well, we know they had no idea what was going on because they failed to treat the infants correctly. But that's the evidence that's been used to convict Lucy Letby. And what people perhaps don't realise is that is the majority of the court case, or it's not quite the majority, but it's a very significant minority, as I will now show you. So if you look at the record of what occurred during the trial, you can see I've highlighted here the bits in the court case, the sections where it's people from the hospital appearing. So here for Child A and Child B, it's approximately 50% of the proceedings. You see, it's always the same structure, parents and police, then people from the hospital, then a bit of medical evidence at the end. So here with Child C, it's probably the majority of Child C. For Child D, it's probably the majority for Child D. For Child E, it's it's probably the majority for child E. For child F, again, it's probably the majority for child F. So I'm not going to go through every single child in the court case because I've already calculated roughly how much was devoted to each of the various types of evidence, or you could describe it as content even, during the court case. And so the court heard from County Chester employees for approximately 47 days. It heard from parents and police for over 21 days. There were 19 days of process and procedure. There were 14 days of questioning Lucy, and there were just over 17 days of medical evidence. I'd just like to mention as well, in the first 10 days, so you think there's 10 days of the court case, 5 days of process and procedure, 2.5 days of parents and the police, 2.25 days of Council Chester employees, and 1/4 of a day of medical evidence. Now, I've heard accounts of people who were in court, who attended the court case, and they said some people in the public gallery had already made their mind up after about 3 days, and there hadn't even been any medical evidence, which you hear so many things that are so worrying with regard to the whole notion of juries. And I'm not here to say you should get rid of juries. I don't wish to argue that, but I'm pretty ambivalent on the capabilities of juries and the capability of the general population to be able to understand a case of this nature. But if you go back to the full days that appeared in the court case, as you can see, if you look at the court case as a whole, 40% of it is these Council Chester employees, and only 15% is medical evidence. But then there's nearly 20 days devoted to process and procedure. So if you take that out, and if you just look at the raw evidence, when I've been saying in previous videos, half of this court case is just people on the Council Chester going, we had no idea what was going on. I wasn't saying that flippantly. It literally is virtually half of the evidence that appeared in court. Medical evidence is a relatively small percentage. Over 2/3 of this court case is the police wittering and bleating on about their nonsense, and then employees from the Council Chester, many of whom were incompetent seemingly, saying, oh, we had no idea what was going on, we couldn't have done anything differently. And then I'm going to break down the medical evidence further still. So Hindmarsh only gave evidence with regard to child F and child L. Only appeared on the 25th of November and the 24th of February. So I wrote 3 days. I can't count to 2. It's only 2 days out of 116. Marnarides gave evidence in relation to A, C, D, I, and O. Only appears on the 29th of March and 30th of March 2023. So he appeared for 2 days out of 116 in the court case. Arthurs did give quite a bit of evidence compared to some of the others. A, B, C, D, I, O, P, and Q appeared on the 2nd of October, 11th of November, 3rd of February, 16th of March, and 20th of April. So he was in the court case for 5 days out of 116. Kinsey, A, B, E, and F, but very minimal amount of evidence she gave, and she only appeared on the 29th of November and the 7th of March, so 2 days out of 16. And then Kenny and Stavaros didn't appear in court and didn't give any direct evidence, so they were in court for 0 days out of 116. So if you actually look at the medical evidence, you always get Dr. Evans saying, oh, I was backed up by loads of witnesses. Literally, this is absolutely true, and this is why I've said Evans is 95% of the prosecution case. Because the actual time in court, 92% of the medical evidence is Dr. Evans and Dr. Bohin. Only 8% is all the other prosecution witnesses combined. Of course, 2 of them didn't appear in court at all. So, considering that all Dr. Bohin has done is had Dr. Evans' reports and conclusions handed to her, and then she said, oh, well, I basically agree with them. Eventually, she agreed with everything. I think she queried a few things here and there, but was eventually won over by the Welshman. And that's the situation. So we now know Dr. Evans has gone through the cases completely on his own. They've arrested Lucy Letby before they even heard from any of the medical witnesses. Dr. Evans hand-waved looking at infection. Dr. Evans hand-waved receiving any of the reports. Dr. Evans hand-waved hearing from any of their experts. Dr. Evans hand-waved receiving the maternity notes or the obstetric notes. Dr. Evans did his reports. We know a little bit more about that now. We know what the police process was like. So then Dr. Evans hands his reports over to Dr. Bohin and his conclusions. And then, in my book, I've just got scientist and medic after scientist saying, I mean, come on, this is not a peer review. This is laughable. And you don't even need a scientific qualification to know that. And that is the brunt of medical evidence that's in this court case. And that's just simply a fact. So, as mentioned, nearly 50% of the active time where evidence is being given, 47% to be precise, is devoted to people from the hospital sitting there saying, well, I couldn't possibly have made a mistake. We had no idea what was going on the unit. I couldn't see any problems with the unit. I didn't know anything about infection. I didn't know anything about any of these sanitary issues. And as far as we're concerned, the baby's just collapsed for no reason. And we'd never had any problems in previous years. And that's literally half of the court case. When in fact, as I mentioned previously, this unit was only a level 2 unit for 5 years. And they experienced problems in 40% of the years. And the first time they had high acuity and low staffing problems and difficult infants and triplets and twins, etc., they failed. And then you called in the people who failed to ask them, did you fail? And they all say no. That's what this court case was. So in summary, there are several themes that emerge from this first portion of the summing up. The first one is numerous basic errors from the judge. For example, he said error in the brain. There's the mix-up with Arthurs and Evans. And he doesn't seem to understand that Evans is not a neonatologist. These are all in the very first page of the transcript. This does not bode well for the summing up as a whole. There's the early presence of the shift chart association. Inferences made from the shift chart are introduced almost immediately by Judge Goss. It is increasingly clear that if Lucy hadn't been charged with malfeasance, it would instead have been one of the other nurses on the unit, and the pitchfork wielders would be condemning that person instead and praising Lucy Letby as having tried her best on the unit, but what could she do when ex-nurse was going around killing babies? Lack of defence expert evidence. The defence had no medical expert presence to counter the prosecution. This means that there is no convincing counter-narrative to oppose the prosecution, as we see very early on in the summing up. And then the judge wipes out counterclaims that are made almost immediately. This was featured in Nick Johnson's cross-examination of Lucy and his closing statement. The fact that a central claim of the defence has been that the unit was inadequate and understaffed. The judge wipes this out almost immediately before the summing up even begins in earnest. Effectively, Lucy was practically defenceless in this court case. Another issue is the BAPM standards the neonatal unit universally failed to meet British Association of Perinatal Medicine standards. Although this was mentioned, even this was misrepresented to the jury. Another misleading impression was over previous years on the neonatal unit. The cancer chest was only upgraded to level 2 in this tertiary system for 5 years, and it failed during 2 of these 5 years, and that happened as soon as the hospital had a challenging acuity with twins, triplets and staffing issues and the other problems we know about, at which point it was immediately downgraded. This was consistently misrepresented in court and is misrepresented here. Then there's an emphasis in the court case on non-medical testimony. A large portion of court time was spent on evidence from hospital employees, parents, and procedural issues rather than medical testimony. Again, it has become increasingly clear that a lot of the court cases, those who worked on the unit, who evidently had no idea what was going on, telling the court, we had no idea what was going on. Evans and Bohin dominate medical testimony in the court case, with 92% of the court time related to medical testimony being Evans and Bohin, compared with 8% for the other 6 witnesses combined. So that's the end of this video on the first portion of the summing up of Judge James Goss. I will return to this in the future. If you have any queries or comments, please do let me know, and thank you for watching.